So here's the thing that no one wants you to know. Excellent service can save a bad meal, but an excellent meal can be ruined by bad service. We think it's time that the front of the house got the spotlight they deserve. Welcome to Dine Dish, where the business of dining meets the art of hospitality. All right, well, welcome everybody. We are back for another episode of Dine and Dish, and we are starting off the new year with so many exciting topics about what it takes to open restaurants, service, building restaurants, reading leases. We talked about how we open restaurants from scratch on our last show, and today we have a very interesting, amazing topic. I'm super excited. I have a guest on that I've been working with for the last 3 months on a private project. So I'm excited to also have him on the show to talk about commercial projects. So let me introduce him and we'll jump right into the show. Paul Stanton is on the phone with me today. He is a lawyer with McCrossin and Stanton in Ocean City, New Jersey. And we are going to talk leases. And he primarily practices real estate and business and transactional law. And Paul, are you there?
I am here. Thank you. I am
Well,
here.
welcome. It's exciting to have you on my podcast.
No, very cool. It's been fun to work together. And then seems like you have a nice little
Yeah,
side thing going with the podcast. And you like to talk and I like to talk. So I think this should be
I
fun.
know, right? We might have more than, we're only supposed to stick to 30 minutes, but with you and I on the phone, it might turn into to more. So before we get started, obviously we're going to talk lease and legal. So, obviously we need to tell everybody this is not legal advice. This is obviously a conversation and suggestions and just some information for everybody, for the listening and the viewers. So obviously if you're looking at leases or looking at a space or getting ready to sign a lease, you should always seek legal advice. Paul, did I did that? Did I do that okay? Is that the
Yeah.
legal disclaimer?
Every state is different. Every project is different. And I think anytime you get involved in anything, you should talk specifically with a local attorney who's familiar with that
Yeah,
area, familiar with that business, and kind of familiar with that market. So everything we talk about is more merely my
yeah,
experience, but should not be construed as he said this, I'm doing this, and I relied upon this. But every lawyer should be consulted. Any lawyer should be consulted prior
yeah,
to
for sure.
entering into, in my opinion, any agreement, because once an agreement is signed, the courts will view that agreement as the end all be all. So I think it's
Yeah, we
very
we know
important.
that, don't we? Yeah. Well, today's show is all about leases. And, we just did a contract for a personal project, but today we're going to talk about commercial leases. And, they're so important. They can make or break your success with your business. And, they can be, we say that leases can be the number one silent killer because most operators don't even really fully understand leases. They don't even know what they're reading. And I can't tell you, I have to tell you a quick funny story before we jump into this. We actually had a franchisee that was negotiating a lease, and this is no lie, and he hired a divorce attorney. And he said, "Oh, my divorce attorney can handle this lease." And Jannar and I were like, "Oh my God." You should have seen the mistakes on the lease. And, thank goodness, we get the final review of it and, we caught a bunch of mistakes. But it's so unbelievable how many legal mistakes and so many issues show up in leases. And a lot of these business operators and restaurateurs don't even know about it. It's
Yeah,
crazy.
well, when you sign a commercial lease, you're signing an agreement, not just to lease the property, but to pay that landlord a certain dollar amount per month for a certain term. So, assuming
Yeah.
the landlord does everything they're supposed to do, you're saying I'm going to pay rent for these months for this many years, and you're bound to that.
Yeah,
So, I guess before we get into, I'm sure you have questions about specific provisions,
yeah,
but
for sure.
in the commercial setting, courts are generally a lot stricter on a tenant and a landlord with a commercial lease than a residential lease. So I find commercial leases are arguably the most important documents that a business can enter because before you know you're making money and before you know you're operating, you've already agreed to a landlord that I am going to pay you X dollars a month for an X term. So that business up front is already making a promise to pay for an extended period of time. So right off the bat, I think the term is one of the most important parts.
Yeah.
Um,
Well, you brought up an interesting. We'll just kind of jump right into the numbers since you brought up the monthly the fees. But when you talk rent, you talk CAM, and we'll talk about what CAM is. Charges, taxes, insurance. You have base rent versus your effective rent, your percentage rent. So there's so many different terms and the whole lingo when you're reading a lease. So what can operators really do to protect themselves from CAM increases? They talk about administrative increases. So, what would be your suggestion for the listeners so they can actually protect themselves from these hidden increases?
yeah, but any document should be able to be picked up and read by anybody and understand what it says. So a lot of these leases and legal documents have vocabulary and have sentences that grammatically might seem confusing. And I think making sure anytime there's an increase or percentage or a dollar figure, it's spelt out so there could be no misunderstanding of what that means. And you'll see a lot in commercial leases, there'll be like charts, like tables that say
Hmm.
year one and then year two it increases. But right off the bat, a tenant should understand what is my rent, what utilities am I responsible for, am I responsible for taxes, and then the CAM charges, which are common area maintenance charges, they're very important to negotiate or at least make sure it's clear because a lot of restaurants specifically um, properties are connected to other properties, and that landlord might own the property next door and then the other property next door. And if they have one shared expense for the whole building, you want to make sure that whatever your CAM charge is proportionate for what you are actually renting. So to make
Right.
sure that CAM charge is clear is very important. And an example that I could use from recent experience is a gymnastics place occupied 17% of the building, and the clause said they will split with the other tenants the CAM charges equally. The other tenant's spot was about 25%. So right off the bat, I was able to say, hey, they should be paying 17%, not the 25%, which in perpetuity for, say, 2 or 3 years could be a substantial figure, which
Right.
to me is making them more profit because they have less expenses. So it's very important to identify what the CAM charges are and ask questions. And who else is paying this? What stores are paying that? And there's various questions that the lawyer is going to ask and make sure that what they are paying is fair compared to what the other tenants are paying. And if it's equal, then they should have everything should be equal. If the building's
Right.
smaller, they probably should be paying less than the other tenant is, at least for CAM charges. But in commercial leases, the landlord can pay anything. You make you pay anything. You hear triple net all the time. A triple net lease is tenant, you're paying for everything as if you own the building, but you just don't own the building.
Yeah. Well, that's landlords love to do that. They love to pay for everything. I mean, we're looking at a space now in Hoboken, and we actually walked away from one of the spaces because it was a mixed use. And we'll talk the difference between mixed use leases and retail and restaurant in a couple minutes. But it was a mixed use, and when I mean that, we were going to take the bottom floor. And then above us, he had rentals, apartments, condos, whatever he was going to do with them. And one of the things in the lease that I caught, we were responsible for all of the sewage lines for the entire building. So if somebody on floor 6 stuffed up all the sewer lines and it came down to my restaurant, it was my responsibility to jet the entire building to make sure the sewer lines weren't backed up. And I mean, I get what he was saying because we were on the first floor and we had grease traps and he was concerned about the grease and the lines, blah, blah, blah. But I went back to him and I said, but this isn't my building. Why am I responsible for jetting the entire building? It was the craziest lease. And there was a lot of other little items in there that we kind of caught that we walked away from. But I mean, that's an example of an item that could have been very costly to us.
Yeah, and then when negotiating that, there's probably should be a sentence that says unless it's been caused by another unit. That's like the key. You want to say unless it was caused by somebody else. But if it's just
Right.
a blanket statement that you're responsible, the reader of that document is going to look at that document and say, this is what it says. You agreed to be responsible for all of it. It's
Yeah.
very hard to go back in time and say, well, we didn't mean that, because whatever's in that contract is what anyone interpreting that contract is going to say, well, that's what you meant. Why would you sign it if you didn't mean it? Um,
Exactly. Exactly. Well, when we're talking about other hidden costs, I mean, I've seen leases where we had a lease it was many years back. I was going to say a few years back, but it was probably 15 years ago, talking about operating and admin costs. I happened to be reading through the extras, and one of the line items was the maintenance and the repairs and everything for the elevators in their main offices. So it wasn't even in our building. It wasn't where our restaurant was, but it was actually in their offices where they kept their management office. And I went back and I said, "Why am I paying for elevator services? We don't even have an elevator." And they went back, of course, and said, "Well, because we manage the property and it's part of our admin and our operating costs." And I mean, I kind of had to fight it and we got away with it and it was finally removed. But that could have been a hidden cost, a line item that, escalated every year because obviously escalations happen, whether it's 2% every year or 3% every year. But that's also a hidden cost that if you don't know what you're reading could cost significant amount of money over 10 years or 2 5-year options, right?
yeah, and there's a likely chance that that landlord was using a lease that they used for another tenant, and he just took that lease and he put your name on it and your property on it and updated the rent, but didn't update the terms. I always just presume that if a landlord prepares a lease that was not prepared by an attorney for that specific transaction, that landlord might have hired a lawyer 10 years ago to prepare a lease for another building and then just use that same document over and over and over. And it was never drafted specifically for this document. And now with ChatGTP, which is
Our friend, right?
it's a useful tool if you use it correctly, but you have to be very specific. And if you say draft me a commercial lease, it doesn't know anything about the property. It only knows what it tells you. So you have to hope whoever's using these artificial intelligence tools are giving it the correct information so it
Yeah.
adequately does it, but still not going to be correct. But I see it all the time where a commercial landlord is using an old lease from another property or a lease that they had drafted 10 years ago and they just update the terms to fit this, but they don't read all 20 pages or however long it is and see that, oh, there's an elevator clause, and that's because the store with the elevator is where I use this lease from. So
Yeah.
I just think
Yeah.
reading the whole thing is very important. But if you're a business, you have fixed cost anyway. You're not going to try to cheap out on the supplier or cheap out on anybody else. I just think that lawyer up front, you pay them their fee. They're supposed to do what's in your best interest, read the document line by line, and then hopefully you never have to call that lawyer again because up front you paid the expense and that lease is fair. You understand it. The landlord understand it. And it's a two-way street. Why would the landlord want a document that's incorrect and could be used
Yeah.
against him because it's so incorrect? I think it's within everyone's interest, landlord's interest and tenant's interest. If you represent a landlord, you want the tenant to have a lawyer. So you both collectively make sure the document's understood and agreed, and then hopefully you never have to look at that document again because everyone up front understands it and agrees to it.
Exactly, exactly. Well, you brought up a good topic. We can segue right into the whole lease conversation. Why a standard lease and standard lease language isn't ideal for restaurants. You made a good point. You can't just take a regular standard lease and just across the board say, okay, here, put their name on it, their restaurant name on it, and everybody sign it. I mean, a standard lease doesn't work. There needs to be so many details, escalations, taxes, insurance, percentage rent, base rent. If there's TA dollars or TI dollars, which we'll talk about it, tenant improvement dollars. But my question is, when should an attorney get involved? I mean, obviously, we've been doing it a long time. We've been in the business 30 plus years. So for us, I know how to read a lease. I have, that's my expertise. I have my broker's license. So I have the ability to have a little bit of experience to be able to read it before we get attorneys or lawyers involved. But for everybody listening, what's your suggestion? Would you say it's important to bring your lawyer on right away before you even start negotiating? I mean, obviously, if you have a broker, you would think they would help you, but when do you feel your attorney or your lawyer should get involved to help with negotiating your lease?
It's always harder to go back and to negotiate stuff. So I think probably as soon as possible before, it depends on how difficult the landlord is. And if you have a broker agreeing to things that might be outside the broker's scope of services, they might agree that everything is as is. We're fine with that. And then the lawyer comes in and says, well, you're operating a business and your business is a restaurant. Have you even inspected any of this stuff inside before you've agreed to as is? So then the lawyer comes in and says, hey, just before we sign this lease, I just want my client to go through and to look at all the equipment and the fixtures in the property. And you
Mm-hmm.
just don't want them to say, well, you guys already agreed everything was fine. So I do
Right.
think from the beginning, plus it does help you. Sometimes you work behind the scenes. Your lawyer doesn't have to get involved. It's just a fluid conversation. Everyone's working towards the same goal. And most of, people hear lawyer and they think litigation in court, but the transactional guys they're just business guys who just make sure nothing goes wrong in the future. So I think having them, right off the bat. Plus, you talked about this earlier, mixed use.
Mm-hmm.
When you go in and to rent a building and say the last tenant was a restaurant, pretty safe to say that that restaurant was probably a permitted use. But you would need to make sure before you negotiate and agree on rent or agree on some of the brokerage terms that you can, in fact, operate a restaurant in that building. And then at the
Mm-hmm.
same time, in a mixed use, you have residential above. Are there any restrictions on the property? Is it a condominium that has some type of document that prohibits noise after a certain hour? So having someone up front will at least maybe save you the time than going down the path. And they might say, look, this isn't going to work, or this will work, but we have to do A, B, and C. So why don't you try to negotiate a lower rental payment in consideration for all the work we have to do to get you up and running? You can't
Yeah,
just
you
presume that.
actually, I want to mention something. You brought up a really good point. We actually had this problem. We were doing a build out, and there was apartments above it, and it was a brand new build out. And one of the items, I mean, thank goodness we were aware and we knew what questions to ask. But when you do a brand new restaurant, besides the black iron, the hood, the venting for the hood, you need to have a scrubber. And this item, this scrubber, goes out the back, and it breaks down any the smoke that comes through the hood. So this way, it's not going up into the apartments and the condominiums. It's going out and it's being washed and scrubbed, so it's clean and it's not going into people's apartments and they're breathing it. And when we were building this restaurant, before we signed the lease, the first thing I asked was, "Are we going to need this scrubber?" And they were like, oh, no, it's fine. We got it approved. It's grandfather, blah, blah, blah. Long story short, we hired the architect. We went to the county and the scrubber was needed. And that scrubber is anywhere from $80,000 to $150,000. So now you're signing this lease for a small 2,000 square foot restaurant. You're putting in a pizza shop or a chicken restaurant or burgers or whatever you're doing. And a typical build out there might be $500,000. Well, now that scrubber just added another $150,000 to your bottom line. And I mean, that affects your profits, it affects everything. So, you have to be educated. You have to know what you're going into and know what questions to ask before you sign that lease. So that was a very good point, because mixed use could really put a wrench, not just in the lease, but in, permits and everything else that goes into the whole negotiation before you even open your restaurant.
And that's why I think retaining local counsel, a local attorney, if you're in just Annapolis, Maryland, that lawyer in Annapolis, Maryland's probably familiar with the code and the city rules and ordinances, which is going to be much cheaper and
Mm-hmm.
much more efficient than getting an attorney from another part of Maryland that's 2 hours away. So local counsel, in my opinion, is always the way to go when you are doing anything real estate, because real estate is very rule specific to that municipality, especially with usages of buildings and code. So that's why, again, if you're buying a spot in Florida, get a Florida lawyer.
Yeah.
You're buying someone in New Jersey, get a New Jersey lawyer. And obviously there's exceptions, but when it comes to business and construction or any type of code specific items, very important to use that local lawyer, because that local lawyer might know right away. I represented someone that tried to do that building 2 years ago and it fell through. And you
Right.
could have that conversation right off the bat. So local representation, I think, is the most important, just due to the each city has its own codes and each city is very different all throughout the United States.
Yeah. So let's jump right into TA dollars. Everybody calls it a little bit different, but we're talking about tenant improvement allowance. And what that means is the landlord or whoever you're renting the space from is allowing money to be put towards the space to enhance the space and help towards the build out. So when we do this, and there's a couple ways you can go about this tenant allowance when you're talking about leases. It can either be put in the lease and it's amortized over so much time in the lease, and that helps personal guarantees, and that will be the next topic we kind of jump into. But what's the best way to structure this so it benefits the tenant? Because obviously, it's not free money. Even though you think it's free money, it's still built into your dollar per square foot on your rent. It's still built into the bottom number. So when the landlord's thinking of what number he wants for that space, it's all kind of built in. So, what would you say is the best way to structure this when you're reading a lease to benefit the tenant before they sign?
Landlord, like anytime you buy a property, especially in a commercial sense, you want to do certain things to the property. And most leases, if they don't have the clause that you're talking about, will have a clause that say tenant, just a loose clause in a standard lease will say something along the lines that tenant is permitted to make alterations or improvements to the property, comma, upon written authorization from the landlord.
Mm-hmm.
Um, and then that clause also might say any alterations or improvements shall become property of the landlord. So you want to be very crystal clear up front, aside from what allowance or what the landlord will deduct or give you some type of, I guess allowance is the correct word, to do and to make to the
Right.
property. You need to make sure up front that you have the discussion. What am I allowed to do? And if the landlord's telling you you could do A, B, C, and D, your response is, well, I want that in the lease. I want in the lease that I'm allowed to install all new kitchen supply. And then that lease should also say, when you're done at the end of your lease, you can take what you put in. So aside from negotiating what allowances or what the landlord will negotiate your rent for, you have to make sure if they're going to give you a reduction in rent or they're going to give you some type of an allowance, I'm assuming the landlord's going to want to keep that equipment. So you need to make a business decision. Is it worth even entering into that, or is it easier to agree to? We will make the alterations, we will make the improvements, but when we leave, we agree upon upfront what we can take. Because, like you said, in the retail restaurant industry, this stuff's expensive. And if
Right.
you're putting big ovens and big vents, you need to have that discussion up front. What am I taking when I leave? And if it's silent to the fact, or there's a clause that says anything made to the property is now affixed to the property, and when you leave, it stays in the property. That needs to be amended. And even if the landlord's telling you on the phone, you can make these not a problem, not good enough, because conversations orally never happen unless they're recorded, but you need that in writing. So that's another thing you need right up front. We're a restaurant business. We're occupying this space. You already have a kitchen. I just want to make it clear we're going to upgrade some of these materials. And then when we keep them, when we leave, we're going to take these with us and we'll put back whatever you had. You have to have that discussion up front. And again, that's something agreed in writing. Um, so you're not faced with well, who owns this? And nothing is
Exactly.
said in the agreement, because then that's what ends up in litigation. That's when the landlord and the tenant are fighting over a breach because it's up for interpretation. But if the lease clearly identifies who's responsible for what and who can take what and who pays what, then there's no argument. And if it's written very plainly, it's very easy to say, well, doesn't this document say exactly what it says? End of our term. We're taking our oven. You agree to it in the beginning. So I
Yeah.
think with any time you make improvements, you should try to agree up front, because you don't want to get halfway through your lease or already signed the agreement, the lease agreement, and then find out the landlord saying, no, you can't do this. And you say, well, I need to for my business. And now
Yeah.
you're negotiating again. You want all the negotiations up front so you can operate your business and not have to ask for any approval from your landlord down the road.
Yeah. So you brought up two really good points. Obviously, every landlord requires some type of an approval for a build out. So they want, if they might say, everything $10,000 or more, or they might say if it requires a permit, then the landlord wants approval. So that's a very good point to make sure that in the lease, that's spelled out. What approvals do you need to build? Because you never want a landlord holding up your project. But the other point too that you talked about, what happens at the end, if you have a 10-year lease, 2 5-year renewals, or what happens if you go into default? It doesn't work out, you don't hit that 3-year mark, you signed a 10-year lease and now you're in default. What happens to the equipment? I mean, and so many standard leases, FF&E, furnitures, fixtures, and equipment, if it's not attached, comes with the tenant. Usually you're allowed to remove that. That's not always in the case of a default. If you're in a default and you owe the landlord money, or you're going to walk away from the lease and you have some type of guarantee, which we're going to talk about in a minute, the landlord might put a lock on the door, and then you have that problem that you just talked about. Who owns it? And that's when you have that problem of going into litigation and getting attorneys involved, and it's one side against the other.
It's way more expensive to get lawyers in after the problem is created, other than trying to get the lawyers in up front to address what could go wrong. And in that event, what do we agree happens? So yeah, the default of the lease is also this, probably the largest item. What happens if your business goes under? What happens if you can't make money and you can't afford your rent? It's a thing that needs to be discussed up
Yeah.
front with the landlord, so you're not just caught off guard. And if you do put 100 grand into the property and upgrade everything and you fail to pay your rent, maybe you guys agree in that case, we'll sell all our equipment and make yourself whole, but they shouldn't keep everything. It should be what do you owe? So
Right.
there's hundreds of scenarios, but again, they're all so specific to that specific rental arrangement and what you want to do with your business, and why I think someone should be consulted every time.
Yeah. Well, I'm going to tell you what, being in this industry, the restaurant industry is probably the toughest industry to be in. It's the most volatile, just like retail. And I mean, last year, I mean, you probably know the staggering numbers, 80 some percent don't make it, and so default language is a huge trap. I mean, it can make or break you, especially with personal guarantees. I mean, nowadays every landlord wants some kind of PG, personal guarantee. That's all they talk about. I mean, I've seen some leases. I just read a lease a couple weeks ago where they wanted the entire 10 years personally guaranteed. I mean, that's crazy. By the time you get past 3 years or 5 years, and the landlord has covered or collected back whatever money they've put out in terms of tenant improvement allowance, or let's say even a rent number. You've paid 3 years into rent, you're not in default, or now you're going into default, your restaurant's not going to make it. I mean, to have a personal guarantee when they're going to go and lease that space, you build it out, you enhanced it, it's now a fully second generation restaurant for someone to come in and release or purchase. I mean, the landlord, it's a win win for them. It's the restaurateur that has the more volatile part in this entire lease. It's like that one side, it's like going to a casino. The house always wins. The landlord always wins. You enhance their space, they own the building, they're getting money, and when you leave, they keep it all and they're going to lease it again. But meanwhile, they have you on the hook.
Yeah, and that's why those default language, every state is different with the law, but you would want the default to, have the landlord mitigate the damages if it's a 10-year lease. And by year three, you default and you can't pay 7 months of rent. And then at the eighth month, they put a new tenant in that spot that's paying the same rent. Well, they don't have any more damages, in my opinion. They only have 7 months of damages because at the eighth month, they're back up and running with a new tenant. So it's very important to negotiate that default and to try to add some language, making it an affirmative obligation for the landlord to mitigate their quote unquote damages by getting another tenant immediately. And upon another tenant being placed in that property, the damages stop. So it's very important to negotiate that as well.
Yeah.
But if you're a new business, the nice thing is if you have a 2 year lease, worst case scenario is I fail at year one and I'm liable for just 1 year rent. So new businesses really should not be jumping into a 10-year lease. And you would try
Exactly.
to negotiate renewal options that gives you leverage that if we're successful, we can renew. But if we're not successful, we don't have to renew and we can get out at the second year. You see a lot of businesses come for questions and they have a 5 year lease. And I ask, how long have you guys been doing this? And they haven't been doing it for long. And they say, well, we want to lock it up for 10 years or 5 years because we can't find anything.
Yeah.
It so instead of saying we agree to the 5 years, why don't we try to negotiate? We'll start with 2 years, and if the tenant does everything they're supposed to do, the landlord will give you an option of another 2 years. And as long as you have that renewal option, you technically have a 5 or 10 year lease. But now you have a say whether you want it to be a 5 or 10 year lease. So renewals are a big aspect too. But
Yeah.
it's all business. It's not just entering into a lease agreement is a very business heavy decision that a business can make. No one's going to enter into a 10-year agreement with Tyson Chicken to deliver 10 years of chicken. Um, they're going to just order as they come. So if you can almost do the rent as you come with renewal options, you're in a much safer spot because then you could always just call Tyson and say, we don't need you anymore. But if they have an
Yeah.
agreement saying, well, no, you told me for 10 years we would be doing this, we're going to keep supplying it and you're going to keep paying it. So
Yeah.
renewals, look at the term first. And as a business owner how successful you can be and what is your worst case scenario. And by calculating a fair term, a fair default clause, you can prepare for worst case. And now you have, hey, if we enter this business, we enter this lease space, the worst case is we're on the hook for X amount of dollars. You want to have that discussion and outline the worst case and then negotiate renewals that you have a say if you renew or not.
Yeah,
Not if the landlord
the
has a
only
say.
problem with that, when you're building these big restaurants, I mean, for fast casual, I can see if you're taking a restaurant or generation location and you don't have a lot of money to put out, then obviously that's great. But if you're going into a location where you have a 3 million or $5 million build out and you're putting in a full service restaurant, in your mind, it's hard to wrap yourself around only signing 2 years with a renewal option. Because the problem is, if that landlord then turns around and says, okay, well, we found a better tenant, they can then go in and take that space back. We always try to do a 10-year lease. I mean, we've been doing this 30 some years and we always do a 10-year with 2 5-year options. We've done some five-year renewals because a lot of like food courts and high traffic city locations, they typically will not do more than 5 years with a 5-year renewal. But a lot of restaurants typically will do longer leases. And that's where you have to really try to limit or reduce those personal guarantees. I do have a question for you, though. I mean, every state is different with what actually stands up in court and what's the true max exposure when it relates to a personal guarantee. I mean, what's your thoughts there? I mean, even though you sign a 2-year personal guarantee, I've heard in many states, if it goes in front of the courts, a lot of times the judge will only um, enforce a max of 1 year. So, what's your thoughts with that?
It's all state specific. And just to piggyback, and I'll get right back. I just didn't know what listeners, what level of people are the people just coming in and listening to
Yeah.
this to say, I'm going to start my own restaurant. I'm going to start small or start big, but
Mhm.
negotiate everything, I guess, is the the takeaway. But when
Yeah.
it comes to personal guarantees, most of the time you see personal guarantees because if you form a new limited liability company and open your restaurant under that new limited liability company, That limited liability company may have been created the week that you signed the lease. They own nothing. That limited liability company has no assets. So if they default, the landlord only has an agreement with that LLC or the corporation, and they have to go after who signed the document. So the personal guarantees are to add the members or who's involved in that LLC to say, even if this LLC has $0 in it, I still have some recourse against you individually. Each state is very different. At least in New Jersey, they
Mhm.
will enforce a personal guarantee for the terms of the contract. Depending on how the clause is written, Michelle on behalf of Michelle LLC personally guarantees. Therefore, they don't have to sue Michelle LLC. And if Michelle LLC owns nothing, they
Mhm.
won't win. But if they have you individually, they'll be able to come after you individually.
Yeah.
Most personal guarantees, at least in New Jersey, will survive whatever the contract term says. It's just a document or a paragraph saying Michelle in her individual capacity will guarantee this lease. Um, so that's another thing. You want to put limitations on the personal
Yeah,
guarantee, but that's
for
why
sure. That's the
wherever,
scary one.
yeah, it's scary. What is, you want to put a limitation? You don't want someone putting something against your house or bringing you into court individually, and you're liable for a massive judgment. Um, and now it's impacting your personal life. You want to keep your business and your personal life very separate. And that's another reason to speak to an attorney, because that attorney is going to be able to give you some type of corporate structure to limit your liability personally. That's why it's called a limited liability company. You want that company to be liable, not you individually. So personal,
Right.
anytime someone says sign a personal guarantee, that limited liability company now is just poof. But to that person, they can come after you individually. So each state, I believe, is different. At least in New Jersey, if you sign a 10-year agreement and you personally guarantee that 10-year agreement, you're going to be liable for whatever damages flow from that agreement. That's why, again, it's very important to consult with that attorney to make sure you're aware what are you individually guaranteeing, because again, you individually guarantee it. Your car is at risk, your house is at risk, your bank accounts are at risk, your second home is at risk, everything's at risk. They're going to
Yeah.
go after you, whatever you own personally. So depending on how risky businesses are, a corporate structure is very important to make sure that in the event something happens, you personally are not going to be impacted. Only the business will be impacted. So that's why personal guarantees are very important to negotiate.
All right. So, Paul, you're never going to believe this, but our show is coming to an end and we had so many more topics to talk about. So,
Bring me
you
back.
definitely
Bring
have
me
you
back.
have to come back on. You're going to have to do
Anytime.
part 2.
I'd be glad. It's all fun to talk about. I mean, everyone wants to be successful,
Of
and
course. So, before you go, and I want to just ask some really quick questions. Let's fire them off with some really quick
I'll be
um,
short. Give them to
answers,
me.
just so we can kind of just finish out a couple quick topics. What happens if the landlord violates a term? I mean, we keep talking about the tenant being in default, but there's times where you have landlord violations. So, how do you handle that in a quick, you know, 2-minute segue into landlord violations?
You want to make sure that lease is very crystal clear on what the landlord's obligations are. And then also the default clause. It should be, you should have any remedy to go after a landlord. Each state, again, is specific. Some give rent abatement. And I'm not, look, the HVAC was your responsibility. The HVAC hasn't been working. We had to close a restaurant. We don't want to just be liable for a rent abatement. You want to be liable perhaps for a lost income. So
Yeah.
again, what are the landlord's responsibilities? Make sure they are spelt out. What are the tenant's responsibilities and what are the landlord's responsibilities?
Yeah, there's got to
And
be
what,
recourse for everybody, both sides.
yeah, in a commercial setting, it's way more of a business than it is with a residential landlord and tenant. Um, so you should fight. The landlord wants something, you want something too. You should certainly make sure those landlord responsibilities are clearly identified.
Yeah. So, all right, one sentence every restaurateur should remember before they sign that lease. One thing.
I would consult with a good accountant, I would consult with a good realtor, and I would consult with a good lawyer and make sure that upfront is protected, because then you'll never have to worry about it and you just focus what you're good at, and that's running the business you want to run.
Yep. I couldn't agree more. Knowledge is power. It's an easy way to leverage to get the best terms for the tenant. And legal doesn't have to be scary. If you have the right people in your court, it's not scary. I mean, they should be there to protect you. And long term is, you have to think winning, and long term thinks winning and success. And especially in an industry that's so tough these days for profits and just overall success. I mean, we want to see around 10 years, 12 years, not just these big corporate businesses and restaurants. The little guys got to win too, and these leases have to be negotiated on their behalf.
A lawsuit could take you out of business if the wrong if you go sue, Warren Buffett. He has enough money to put 100 lawyers on you and just make sure you can't afford your lawyer anymore, and he wins that way. But a good
Yeah.
agreement could stop them right in their tracks. But like you said, it does not need to be scary. It's two transactional lawyers. Hopefully, the landlord has a good one, the tenant has a good one. Their job is to make sure both their clients get the best terms. And most of the time, you have a landlord's attorney. He represents tenants too, so he sees it from both sides. Let those guys negotiate the lease. Let the realtors negotiate the payments. And then once that's done, lease is signed. You should never go back and look at it again. And now you just focus on what you have to focus on.
Yeah, isn't that the truth? They say that once that lease is signed, it should be put in the drawer, never looked at again. But if that default happens or that restaurant goes down and that lease comes out, you got to make sure you're protected.
And you're going
So,
to be very happy you consulted with the proper people at that time, because now you already know your worst case and it's already been agreed
exactly.
upon.
And there's no questions. So, but
Right.
that is our show, and DMs are open. We love to hear from you. So please, write in. You can connect on Instagram. You can feel free to reach out to us through restaurantdiva.com. We'll be posting Paul's information if you have any questions. If you're opening a restaurant or any location, commercial or residential in New Jersey, in the New Jersey area. And Paul, thank you so much. I would love to do part 2 of leases and commercial real estate if you have some time in the near future.
Absolutely. It was a great
And
time,
we'd love,
Stephen. Thank you. Thanks to everybody. Um,
yeah, we'd love to have you back. And that's another episode of Dine and Dish. And we will see everybody next week. And we'll be live every Wednesday at 6 a.m. Talk to you soon. Thank you so much, Paul. Have a great night.
Thank you very much.
Thank you.